I'm absolutely delighted to be here with you today. My name is Aoife Nolan. I am co-lead of the Children's Rights Group here at Doughty Street Chambers, and I'm delighted to welcome you on behalf of everyone in the Children's Rights Group. And the group brings together barristers from across all practice teams in Chambers to focus on innovative legal advocacy aimed at securing the rights set out in the UN Convention on the Rights of the Child. And we are thrilled to be here to launch this guide on criminal practice directions. And this is the most recent guide to emerge from the YJLC Doughty Street Chambers collaboration, of which we at Doughty Street Children's Rights Group are enormously proud. Doughty Street Chambers would like to express sincere thanks for the fantastic work done in authoring the guide by Catherine Hollingsworth and Shauneen Lamb. And we're particularly pleased to have our Chambers colleague Daniela Wadouk speaking today, given her role in producing the guide. I now have the pleasure of handing you over to Katja, who is co-head of the Youth Justice Legal Centre, who will be chairing today's event. I look forward to the conversation. Thank you.
Sorry, Aoife, it's actually Shauneen Lamb who's going to be chairing. Katja handed the task over to me. But welcome everybody, and thanks so much Aoife and Doughty Street Chambers for hosting this event. Again, I think it's the 5th in our collaboration, which has created these brilliant and we hope really useful guides for practitioners in the youth justice system. As I'm sure many of you know, the Youth Justice Legal Centre began in 2014 to establish a centre of legal excellence for youth justice practitioners and to create resources like this guide and a community of like-minded professionals. This is the 6th guide in the series. The 5 before have been Turning 18, Intermediaries for Child Defendants, Child Criminal Exploitation, Criminal Behaviour Orders, and Trauma-Informed Lawyering. This guide, the Criminal Practice Direction, was initially put together by myself and Professor Catherine Hollingsworth in response to what we saw was an expansion of protections for vulnerable defendants, but perhaps alongside that, a narrowing of specialist protections for children within the Criminal Practice Direction. And it's been amazing to have Daniela Wadouk involved in from Doughty Street Chambers Children's Rights Group to co-author the guide with us. It's intended to assist lawyers representing children in the criminal courts and most oftenly in the adult criminal courts, particularly in the Crown Court, and explains how the Criminal Practice Direction should be able to support in this context. It is well known that many children appearing in the criminal courts have communication or learning difficulties, and these factors alongside age and adolescent development can make it very difficult, traumatizing, and intimidating for children to participate in legal proceedings, particularly those in the Crown Court. We hope that the guide provides practical support to practitioners on how to use the Criminal Practice Direction to get the modifications needed to allow children to effectively participate in criminal proceedings. So without further ado, I'm going to hand over to our first speaker. We have 4 speakers this afternoon. First, Mr. Justice William Davis. Mr. Justice William Davis sits on the Criminal Procedure Rules Committee and so is integral to the powers contained within the Criminal Practice Direction and the Criminal Procedure Rules in that regard. He is also the judicial lead for youth justice, and so we're extremely grateful for him giving his time today to speak to us in that capacity. He has been at the bar for over 30 years, 10 years as a QC, before becoming a senior circuit judge in Birmingham in 2009, and was appointed to the High Court bench in 2014. Mr. Justice William Davis, thank you so much for speaking to us today.
I'm now unmuted, so you should be able to hear me. I'm going to simply introduce the CPR, Criminal Procedure Rules, and the Criminal Practice Direction, which have their origins in a review of the criminal justice system conducted by a very distinguished judge, Lord Justice Old, completed in 2001. And if you could move to the next slide. In his review, he considered very many topics, not all of which, I'm sad to say, have been put into effect. But one which was put into effect was the creation of a criminal procedure rule code. And you see on the slide the recommendations he made, the last of which I read with amusement when I was researching this talk. When first set up, the Criminal Procedure Rule Committee did indeed have a staff of lawyers. It was 6 at the outset. Since 2012, the full-time staff of lawyers has consisted of 1 person. He's an extraordinary man called Jonathan Solly, and he runs it single-handed. But the staff of lawyers, I'm afraid, is a thing of the past. Next slide, please. The consequence of Old's review was a series of provisions in the Courts Act of 2003. And Section 70 identifies the membership of the Criminal Procedure Rule Committee. The Lord Chief Justice is the chairman of it, but in name only. I've been a member of the committee for 4.5 years, and he has attended 1 meeting of the committee, and that was simply to hand over the vice chairmanship from Sir Brian Leveson to Lord Justice Fulford. He pays keen attention to the work of the committee. He's briefed each month about the agenda, but he simply doesn't have the time to attend. It's actually chaired at the moment by Lord Justice Fulford, as well as the lawyers, voluntary organisations. There's a senior police officer and the DPP. Anybody appointed to the committee is appointed for 4 years. They're almost inevitably renewed for 4 years, and after that, new members have to be found. If it's a judicial or professional member, then there'll be a public appointment exercise of some sort, or an expression of interest within the relevant sector. And it's very worthwhile work indeed. Next slide, please. Section 72 identifies how the rules are made. The committee, before it makes or amends a rule, has to consult with whomsoever it thinks appropriate. If it simply went ahead and made a rule without consulting anybody, I'm tolerably sure it would be subject to a successful judicial review. And the statute actually says in terms the committee has to meet to discuss the proposed rule, which it most certainly does. And any rule of any significance is discussed several times before it finds its way onto the statute book. The consultation isn't just in terms of the committee saying, here's a rule we're planning to make, what do you think? We respond to approaches. For instance, if the Court of Appeal or the Divisional Court say something about the rules that needs changing, we respond to that. And more particularly, we'll respond to outside bodies. So if for instance, the Youth Justice Legal Centre has a particular view they wish to press, then the committee will respond to it. Certainly Just for Kids Law has been involved on a number of occasions with the committee. The next slide, please. This is what we're talking about today, practice directions, and it has a statutory basis in section 74. The section gives the Lord Chief Justice the power to give directions as to the practice and procedure of the courts. There's nothing in the legislation about the Rule Committee. It doesn't suggest there's any role for the Rule Committee in the criminal practice directions. In fact, the committee is closely concerned with them. Most of them originate within the committee. They discuss them and then liaise with the Lord Chief Justice as to what should be put in them and what should not. The previous Lord Chief Justice was very proactive and was a great author in his own right. The current Lord Chief Justice, amongst other things, has many things on his mind other than the criminal practice directions, and tends to rather more take the steer from the committee. But they remain his directions, not the committee's. Next slide, please. They are currently under the process of review, because the current iteration is in excess of 250 pages, should you choose ever to print it out, though in fact they're published electronically, and each part is published in a particular section associated with the relevant chapter of the criminal procedure rules. The review process was supposed to have been concluded early this year, and the new practice directions published in April. You will have observed that hasn't happened. I don't know precisely what the current timetable is. It certainly won't be before the end of the year, I don't suppose. But the review process won't change the purpose and ambit of the directions in any significant way, I don't suppose. The idea is to make them more accessible. Next slide, please. The most important single sentence or series of sentences in the criminal practice direction appears at part 1A.3. And the first sentence is the critical one. The rules and the practice directions are the law. So practitioners, if they find something in the practice direction which they consider assists them, provides the basis upon which they should make an application to the court, then the practitioner can do that in the sound knowledge that they are seeking to apply the law. I have to say that's something that passes many people by, not least some judges. Briefly then, what's the difference between the practice directions and the rules? Next slide, please. I'm going to use an example just because it's easiest to use examples. And it's an example I think that's going to be touched on by others who follow. The example I give is intermediary for a defendant. There is a rule about intermediaries for defendants, which, as you'll be well aware, is a facility that's not statutory. The relevant provisions of the 1999 Act don't apply, at least currently, to defendants. But there is a rule. It's 18.27. And you can see that the rule provides not just a power, but a requirement to exercise a power where there's a diminution of a defendant's ability to participate. And one of the reasons why that might happen is because he or she is under 18 and the appointment is necessary. The next slide, relatively small type, it's subsection 2 of the rule, and it sets out in some considerable detail the things that the court must have regard to when considering the appointment of an intermediary. So it's a checklist that must be gone through. So there's the rule setting out what must be done in relation to intermediaries. The next slide is subsection 3, and the court is given the power, it's a discretion, to appoint an intermediary in effect for however long or however short a time is thought appropriate for the particular person for whom the intermediary is being appointed. What is important is in subparagraph 4 that the appointment exists not just to sitting next to the defendant in court and assisting the defendant in court, it extends to facilitating the defendant's communication with legal representatives. So that's the rule. It's a set of clear directions. This is what you must do / this is what you may do. But the practice direction also deals with intermediaries. Next slide. The paragraph is discursive. It refers to authorities. So it refers to the inherent power that the court has to appoint an intermediary. It refers to the fact that if an intermediary is not appointed, the trial process has to be adapted. And it sets out the possibility of a defendant being accompanied by somebody other than a qualified intermediary. And the next slide is 3F.13 and is probably the more controversial of the practice directions in relation to intermediaries for defendants, because it concludes with the sentence, directions to appoint an intermediary for defendant's evidence will thus be rare, but for the entire trial, extremely rare. Now, that sort of discursive approach is mirrored throughout the practice directions. It's not a set of bullet point rules or directions. It's a discussion of the sort of approach that a court might take. Because the practice direction is not kept under such close review as the rules, it can, and in this case is, out of date. Whilst it is the law, it's the law because it's drawn from particular authorities. And in the case of intermediaries, for instance, the law in terms of decided cases has moved on. In the Court of Appeal, Dean Thomas, in the Divisional Court, TI and Bromley Youth Court. And so in applying the practice direction, you have to bear in mind that it may well be that there's authority that postdates the practice direction, which is not undermined by the practice direction. The criminal procedure rules, on the other hand, are what they are, the rules. So with that general introduction, I'll pass you back to Shoneen.
Thank you so much. That's really, really insightful for practitioners to recognise that the practice direction can become out of date by continuing case law. It's one of the things we've been grappling around, the issue of intermediaries. So thank you so much for the clarification. The next speaker I'm very glad to welcome is Professor Catherine Hollingsworth, who co-authored the Criminal Practice Direction Guide. Catherine is a long-time ally of Just for Kids Law. She was a trustee there for many years and remains on the advisory board of the Youth Justice Legal Centre. But much more than that, in her day job, Catherine is a professor of law at Newcastle University. Her research focuses on children's rights, especially in the context of youth justice. So her research and expertise is particularly relevant for this guide. And she's published widely as an expert in this area. She has a particular interest in the theorization of children's rights, and as well as their practical application. Catherine is also interested in judicial approaches to children's rights, including how children's rights can be incorporated in judgment writing and sentence delivery. She's worked with the Judicial College on judicial communication in sentencing, and also delivers training to members of the judiciary in other jurisdictions, including New Zealand. Catherine, welcome, and thank you so much for speaking today.
Thank you so much, Shoneen, and thank you for inviting me to speak. So I'm going to give an overview of the children's rights perspective on the criminal practice directions. So first of all, I'm going to set out briefly the broader context of children's experiences in court and the children's rights framework, and then I'm going to consider how this is informed and is reflected in the CPD. Next slide, please, Richard. So thinking about that broader context, first of all then. So first of all, we know that there are now far fewer children in the criminal courts than say 15 years ago. So for judges, particularly in the Crown Court, it may be quite unusual for them to see a child defendant. They're not going to see that many of them day to day. So this may mean that some judges are less familiar with the CPD as it applies to children and the modifications that might be necessary to ensure children can effectively participate in court. Secondly, as Shawneen noted at the outset, for those children who are in court, we know that between 60 to 90% of them have significant problems with speech and language or other communication difficulties. There's a much higher prevalence of specific learning difficulties, traumatic brain injury, and so on. So children in the criminal justice system are often doubly vulnerable then, on account of their age or developmental stage, combined also with this high prevalence of communication needs. And we also know that many of these vulnerabilities and disabilities are not diagnosed until after sentence. So it means then that many children don't necessarily have the levels of support that they need when they are in the criminal courts. We also know that there's a disproportionate number of Black and minority ethnic children and looked after children. And these are children who may have experienced discrimination or disadvantage in the criminal justice system prior to their appearance in court. And so they may have less trust in the court, in the legal proceedings, and that might heighten the need for fair processes. And finally, of course, we know that resource pressures at all stages of the system add additional challenges regarding children's participation in court. Next slide, please, Richard. So this means that children, again, as Shawneen noted, find court, the trial, the sentence, a highly anxious time. Their level of understanding is very low, and their ability to understand and participate is compromised further because of those heightened emotions and the anxiety. And you can see this here in these quotes from my own and other people's research about how children experience that court. Next slide, please, Richard. But crucially, the international rights framework makes it very clear that the right to a fair hearing includes the right to effective participation. And we see this reflected in Article 40 of the UN Convention on the Rights of the Child. And Article 40, which is quite brief in terms of reference to a fair hearing, is fleshed out, is given detail, if you like, in what's called General Comment number 24. This is produced by the UN Committee on the Rights of the Child, and it helps us to interpret what's required of the child's right to a fair hearing. And we can see here on the slide the requirements that General Comment 24 places forward. So both Article 40 and its interpretation in the General Comment must be used to interpret and understand the requirements of children's domestically enforceable rights under, in particular, Article 6 of the European Convention of Human Rights. So this is the kind of detail that we are looking at in terms of what children's rights require in this context. Next slide, please, Richard. And we saw, I'm going back in time a little bit here to 1999 and the European Court of Human Rights decision in the case of V against the United Kingdom. And this was the case that I'm sure you're, probably everybody is very familiar with, in terms of where the Strasbourg Court, the European Court of Human Rights, was asked to examine whether the two young boys who were convicted of the murder of James Bulger in 1993 were able to effectively participate in their trial. And I've got the quotes from that case on the slide here. The court said that full account must be taken of the child's age, level of maturity, and intellectual and emotional capacities, and that steps must be taken to promote his ability to understand and participate. And also that the hearing must be conducted in such a way as to reduce as far as possible his or her feelings of intimidation or inhibition. So shortly before this decision in V against the UK Parliament had passed the Youth Justice and Criminal Evidence Act 1999, and this is the act that provides for special measures for vulnerable witnesses, including children. But crucially, the definition of vulnerable witnesses at that time explicitly excluded defendants, including child defendants. Now, although the Youth Justice and Criminal Evidence Act was passed before this decision in V against the UK, it was passed after the European Commission on Human Rights, which at that time acted as a filter for the court, had earlier pronounced that there had been a violation of the boys' Article 6 rights. So Parliament should have been aware that this negative judgment was going to be coming. So we might conclude then that they purposefully, or perhaps purposely, didn't want to address the problems in legislation. So instead, the resolution from England and Wales to that decision in V against the UK came in the form of a practice direction, which is the sort of starting point for where we are today. So next slide, please, Richard. So this is the practice direction as it was originally in 2001, as it applied, as you can see, to Crown Court, to young defendants in Crown Court. And this practice direction applies specifically and exclusively, so only to young defendants and to all young defendants, those aged 10 to 18. So you can see from the slide that this original practice direction in 2001 included an overriding principle for all youth defendants that emphasised that the trial process shouldn't expose the young defendant to avoidable intimidation, humiliation or distress, and that all possible steps should be taken to assist the young defendant to understand and participate in the proceedings, and that the ordinary trial process should, as far as necessary, be adapted to meet those ends. And we also see a reference there to the obligation on the courts to have regard to the welfare of the child under Section 44 of the Children and Young Persons Act 1933. So the purpose of the CPD then for young defendants was very much to better protect the child's right to effectively participate. And the provisions within the CPD mirrored a little bit the special measures in the Youth Justice and Criminal Evidence Act, not entirely, but sort of similar issues were there. And you can see that it very much draws special attention to the status of children as children. So next slide, please, Richard. Now, in 2013, the protections in the CPD that applied to young defendants were extended also to other vulnerable people. And you can see that in the extract here. And the definition of vulnerable people then was those under 18 and also people with a mental disorder or learning disability and so on. Now, Ed and Daniela are going to speak about the details of the protections afforded by the CPD later and how to use it most effectively. But I just want to finish by observing two things related to this extended definition of vulnerable defendant. So next slide, please. So the first point I want to make is that the shift towards better rights protection for vulnerable defendants, and that's a category that includes children, as I said, alongside people with mental disabilities, impaired intellectual and social functioning, and physical disabilities. Although that's very welcome, that extension to other types of vulnerable defendant, it may arguably, as Shauneen and I argue in the chapter that's referenced there, be associated with a diminution in the protection of children's rights per se. And what we mean by that is that the amalgamation of children within this broader category of vulnerable defendant arguably risks obscuring or discounting the vulnerabilities that arise from age per se. And this could have two consequences. First, it means that the double disadvantage that faces vulnerable child defendants, so child defendants who also have an additional vulnerability, such as diagnosis of autism spectrum disorder, for example, isn't necessarily fully recognised in the CPD, and therefore is not going to necessarily be fully recognised when children appear in courts. So the adaptations or support may be inadequate because they fail to take account of that combined impact of age and disability. Secondly, in practice, and you see this in some of the case law, it can mean that children have to show that the court is looking for, if you like, an additional vulnerability, such as autism spectrum disorder, in order to get the protections owed to them as children. So if the child doesn't have that additional vulnerability, if their only vulnerability is age, then the courts may not see the urgency or the need to apply the modifications set out in the practice direction. So we want to make sure that both of those things, age and any other additional vulnerability, are taken into account when considering what modifications under the CPD are necessary to ensure the child's right to effective participation. The next point I want to make really is that it does seem from the research evidence of children's experiences that I had on the earlier slide, from the experience of advocates and maybe your own experience, some of the attendees here, and also from the Equality and Human Rights Commission, that children's right to effective participation is not being adequately protected despite the CPD, and that there is a failure in even some of the most serious cases to adhere to or even refer to the CPD. And in part, the Equality and Human Rights Commission say this is due to inadequate training of the judiciary and practitioners. But it's really important, I think, to note that there are examples where children have more positive experiences in court and where their outcomes are better, where the modifications of the CPD are followed. So in those circumstances, children's rights are better protected. So I'm glad to have contributed to this guide. And I think I should say that Shauneen and the YJLC colleagues did a lot of the work here. But it's a very welcome addition to the set of guides that they've produced, and hopefully will increase awareness and use of the CPD for children. Thank you.
Thank you so much, Catherine. And I think it's really important for all of us as practitioners to remember that special status that child defendants have as a child, as well as this separate one that might come under a disability. And I feel like there has been progress within that since perhaps, well, I hope since the Equality and Human Rights Commission intervention in the case of McGill and Hewitt. But really, that's the aim, I suppose, of the guide, is to alert practitioners to being able to make those arguments. So thank you so much for really expanding upon that. Our next speaker is Ed Smythe. Ed is a criminal litigation solicitor and partner at Kingsley Natley. A mark of the high regard in which Ed is held within the profession is his membership on the Criminal Procedure Rule Committee, alongside Mr. Justice William Davis, who's our first speaker. The Rules Committee is a lawmaking body, and he sits there with not just members of the judiciary, but I think also the DPP, members of the CPS, the police, and the Ministry of Justice. Ed deals with clients facing a wide range of criminal allegations, from sexual offences to extradition and white-collar crime. He specialises in advising clients prior to or at the early stages of an investigation, with a view to preventing further legal action, and works alongside his clients beyond the criminal law, for example, in employment, family, or dispute resolution, to provide a comprehensive solution. At the other end of the criminal process, Ed is regularly instructed to advise on challenges to police cautions, appeals against conviction and sentence, and applications to the Criminal Cases Review Commission. Ed, welcome, and thank you so much for bringing your insights to the webinar.
Sorry, unmuted. Thank you, Shauneen. Good afternoon, everyone. I'm going to speak to you this afternoon about the practical application of the criminal practice direction, how solicitors can use it in the preparation of a case, and how to achieve best practice. And I'm going to focus on an area covered by the practice direction that isn't specifically related to children or young people, or that does touch on it in certain areas. And before I start, can I please ask you to forgive my woeful PowerPoint skills? So definitely worse than everyone else's. I've chosen to cover an issue that I think will be likely all too familiar to those of you who practice in the magistrates and youth courts, and that is the adjournment of trials, and specifically the adjournment of trials on the day of trial. Next slide, please, Richard. The relevant part of the CPD for these purposes is Part 6, Trial 24C. So I'm going to really give you a short commentary on the practice direction, in the course of which I hope you'll pick up on how it can be used in preparation, both before and in court itself. Now, even where the parties to criminal proceedings abide by their duty under Criminal Procedure Rule 3.3 to actively communicate during the course of a case, and of course we recognise that's not always achievable, circumstances can still nevertheless lead to applications to adjourn on the basis that it would be unjust to proceed for any particular reason. And the courts have a discretionary power to adjourn under Section 10 of the Magistrates Courts Act 1980. What the CPD makes clear is the starting point for the court is that a trial should proceed, and that adjournments are a last resort. And citing a 2015 judgment of Lord Justice Gross, the practice direction expressly warns against a culture readily permitting an opportunity to correct failures of preparation. So preparation is key. Courts are also reminded of the automatic right of appeal by way of rehearing from the magistrates and youth courts to the Crown Court, presumably so that they can take some comfort that any actual injustice that may arise from the refusal of an adjournment is at least capable of remedy. It's also expressly acknowledged in the criminal practice direction that an imperfect trial may be the result of refusing an application to adjourn, but that in and of itself is not a reason to adjourn. So the system expressly tolerates an element of imperfection. Next slide, please, Richard. So Direction 24C.9 lists relevant general principles for a court to consider when deciding an application to adjourn. And these include that proceedings in the magistrate's court must be simple and speedy, and that perhaps harks back to the acceptance of imperfections. Where the situation the court is dealing with is a prosecution application for an adjournment, it has to consider the public interest in trying cases thoroughly, convicting the guilty and acquitting the innocent. And it may be that you can see in that a slight steer towards tolerating prosecution applications for adjournments if they're made on sound basis. Where it's the defence that's seeking an adjournment, the question the court must ask itself is how compromised would the defendant be in advancing their case without an adjournment? Next slide, please. Two significant questions for the court to ask itself when deciding applications are who is at fault and how long is sought. So firstly, the relevance of fault. Where the reason for an application being made arises through the fault of the applicant, that weighs against the adjournment being granted. And the more serious the fault, the greater the weight that will be put in the balance against that adjournment being granted. But what practitioners must always be aware of is the duties imposed on them by the criminal procedure rules, rules 1.3 and 3.3, to inform the court promptly about either procedural failures by themselves or the other side, or matters that may affect the progress of the case, and the exhortation to communicate effectively throughout proceedings. Because you may find yourself as a party opposing an application to adjourn which has itself failed to comply with the duties set out in the criminal procedure rules. And if that's the case, you're likely to find that failure counting against you. In terms of length of adjournment, the simple rule is the shorter the better. Indeed, the court in the practice direction is asked to consider whether it might be possible to adjourn to later in the same day to achieve justice, court timetable permitting. And also where circumstances for the reason for the adjournment is to raise or explore an issue that has only been identified late in the day and may take some, albeit short, time to investigate further. Is there a good reason for such late identification? And is there any reason why the court was not notified sooner? Next slide, please, Richard. So how is the court to deal with particular grounds of adjournment applications? I'm only going to deal with those where it will typically be one or other of the parties that's seeking an adjournment. So I won't be looking at, for example, adjournments for lack of court time, which is really normally a matter for the court and its case management role. For defendants, for adult defendants, there's a presumption in the absence of the defendant that the trial will proceed where no reason is offered for absence, and the court is not required to conduct any sort of investigation into the reasons for that absence. Well, the situation for defendants who are under 18, obviously more relevant for our purposes this afternoon, is different. There is no such presumption of proceeding in absence, and instead the court must consider a number of factors which include various points both for and against granting adjournments. Firstly, the court must be mindful that it's possible for a defendant to be acquitted in absence and that it's in everyone's interests for acquittals to be reached promptly. And so therefore maybe there is merit in proceeding without a defendant. Again, the court is reminded of the automatic right of appeal by way of rehearing and the right to reopen convictions in absence. Crucially, the age, vulnerability and experience of the defendant must be taken into account. The younger the defendant, the more vulnerable, the less experience they have of the criminal justice system, the more likely it is that the court may consider an adjournment. The interests of co-defendants or witnesses who have actually attended court, the impact on them of further delay, the impact on the ability of witnesses and co-defendants to clearly remember incidents that are going to be the focus of the trial. And how soon can the matter be relisted? Again, the shorter the better, and if it's a very long time before the court can find time for it, that will certainly militate against allowing the adjournment. Applications for adjournment in the absence of a witness are treated slightly differently. The court in this circumstances is required to conduct a rigorous investigation into the reasons both why the witness is absent and what steps have been taken to secure the witness's attendance. The court must also look into the relevance of the witness's evidence. For example, can it be agreed or can it be reduced to admissions? If it's a defence witness who's absent, we go back to compliance with the duties under the criminal procedure rules, and the court will consider whether proper notice was given to both the prosecution and the court of the intention to call that witness. And if notice wasn't given, you can see where the court is going to fall. Situations where evidence has not been served in time, the direction points out that matters of service of evidence should always be dealt with well in advance of a trial date, if only that was always so. And so applications to adjourn on the day of trial for lack of evidence should be rare. Once again, if a party is complaining of non-service on the day of trial, the court will consider whether that's a matter that should have been raised earlier. Further rigorous inquiry is demanded of the court into the nature and importance of the evidence concerned, and whether indeed it might actually be preferable to refuse to admit certain evidence rather than to contemplate adjourning for it to be served. And finally, failure to comply with disclosure obligations, again a very regular feature of life in the magistrates and youth courts. Well, as you'll know, disclosure is governed by the provisions of the Criminal Procedure and Investigations Act and is not, strictly speaking, an issue for trial. Any problems should therefore have been resolved before the day of trial. Unless the defendant has served a defence statement, which is voluntary in the magistrates and youth courts, then if the prosecutor has purported to comply with its initial disclosure obligations, that's the end of the matter and the court has no jurisdiction to intervene. If there has been a defence statement, any application for further disclosure must be made under Section 8 of the CPIA, and the court should consider hearing any such application immediately, potentially ordering disclosure that day and giving the defence time to consider it before cracking on with the trial. Next slide, please, Richard. You will have noticed, I hope, a theme that compliance with the criminal procedure rules will generally stand you in good stead. And the criminal practice direction, with its narrative style, is a very useful, accessible roadmap to the criminal procedure rules, notwithstanding the warning we've heard already today to make sure you're up to date on the case law and there isn't something superseding the direction. A good way, the best way to achieve compliance is to develop the discipline of regular communication with the court and the prosecution. Now, the reality is this may more often be a monologue than a dialogue, seemingly producing little in the way of concrete outcomes, but being able, when required, to demonstrate examples of communication or engagement, which can be done by simply maintaining a record of emails sent, for example, can provide significant support if and when you need to seek an adjournment, and significant protection against criticism. I hope you'll also have picked up that consulting the relevant part of the criminal practice direction, depending on which aspect of procedure you happen to be dealing with, can provide you with invaluable guidance. In conclusion, therefore, and rather conveniently, you should find that using the CPD to good effect in preparation overlaps considerably with achieving best practice. Thank you.
Thank you so much, Ed. And of course, I think we would encourage all practitioners to refer to the criminal practice direction and also the criminal procedure rules when making arguments on behalf of their clients. As Mr. Justice William Davis noted, it does pass some judges by that it's law, but it's clear that it's there. And then it's very persuasive to be saying this, 1A3 is makes it a requirement in law. So we would encourage practitioners to do that. Thank you, Ed. Our final speaker is Daniela Wadda. Daniela is also a co-author of the Criminal Practice Direction Guide, and we are so grateful to her for spotting the late changes in the criminal procedure rules just as we were going to publication, particularly around the issue of intermediaries that Mr. Justice Davis brought to our attention, meaning that the practice direction can therefore be a bit out of line with more recent authorities. Thank you, Daniela, for that. Those recent amendments to the criminal procedure rules are within the guide around intermediaries, and we would encourage practitioners to look and refer to those. But as well as being the super sleuth in the guide, Daniela is a barrister at Doughty Street Chambers. The focus of her practice is in criminal justice and mental health and capacity. She has a busy criminal trial and appellate practice, but also undertakes work in related areas, including prison law, crime-related public law, and mental health law. Daniela is well recognised and for her commitment to representing vulnerable young defendants. In 2017, she was given the Rising Star in Youth Justice Award by the Youth Justice Legal Centre. She does a great deal of pro bono work, including providing training to probation and prison staff to promote understanding of the entitlement of children and young people in custody with special educational needs to appropriate educational support and provision. So you can understand why she's an excellent speaker for practitioners in getting a better understanding of how to use a criminal practice direction to make modifications for child defendants. Thank you so much, Daniela. Over to you.
Thanks, Shauneen, and hello, everybody. What I'd like to do in this last session is to give you 5 practical tips that hopefully will help you get the most out of the criminal practice direction and the rules for the benefit of your young clients. And what I'd really like to emphasise as an overriding point is, whilst the criminal practice directions are not perfect, and we've heard about some of the limitations already from other speakers, in many cases they are your friend. They can be a really valuable resource. They certainly represent a real sea change in criminal procedure, and they do that by codifying a lot of really good practice and also removing scope for inconsistency. So when we as practitioners come at judges from the perspective of the criminal practice directions, that can make our arguments really quite powerful and effective. And I think it's just important to bear in mind, these aren't a stick to beat judges with. Instead, it might be more helpful to think about them as a tool by which judges can't avoid going through the proper processes. So if we could have the first slide, please, Richard. This is my first tip, and that is to be proactive. So Criminal Procedure Rule 3.32F is a very recent insertion to the criminal procedure rules. It reminds us that we as practitioners are duty bound to alert the court to any potential impediment to our clients' effective participation. And that makes sense because in many cases, if we don't discharge our duty in that respect, then the court isn't going to be able to discharge its duty to identify the needs of witnesses at an early stage and to make appropriate provision thereafter. So in the Crown Court, we can expect to be having a detailed discussion about these issues and seeking directions at the PTPH. In the Youth Court, you can certainly raise these issues at the first appearance, but as I've set out here on the slide, do be clear with the court that you may need time, you probably will need time to make inquiries, to gather necessary evidence, so that your application for modifications or adaptations can be as strong and as fully reasoned as possible. And in the Youth Court in particular, it might therefore be worth fixing at the first appearance a case management hearing so that you can have those arguments properly when you're ready to have them. In the early stages of case management, you might also want to be fixing a ground rules hearing. The criminal practice direction makes clear at 3E.2 that a ground rules hearing is good practice in all cases involving young witnesses and or defendants with communication needs. and it's required as a matter of law in trials where an intermediary is present. That hearing should be well in advance of the trial to allow time for an advocate's questions to be adapted. And what you are hoping to get out of that essentially is a structure, a framework within which everybody knows what are the appropriate questions that can be asked. So in that context, when we're trying to be proactive, it's really helpful to start thinking about the question of evidence right from the get-go. And I'm going to come to that in more detail. That's my top tip number 4. Particularly important if you are considering applying for an intermediary, given the number of hurdles that you in practice do need to jump through. But be thinking about these issues right from the beginning would be my first tip. Next slide, please, Richard. My next tip would be to do everything that you can to make the court's job easier. You want to help the court to comply with its duty and use the criminal practice direction to do that. So judges know that these are mandatory provisions. They do get, I think, at least that training and that important point conveyed to them. So ultimately, you're going to be doing them a favour if you can make your arguments through the lens of the criminal practice direction and help them to be doing their job. So the criminal practice direction requires the court to take every reasonable step to encourage and facilitate the participation of any person, including the defendant. And sometimes it might just be worth spelling out that that includes not just enabling a defendant to give their best evidence, that will often be a pinch point in the proceedings, but also to understand the proceedings more generally, so that your client can play a meaningful part in those proceedings, because ultimately those proceedings are about your young client, and it's to enable them to engage fully with their defence. So it's about having a really broad understanding of what effective participation means. Sometimes it's necessary to remind judges of that. The aim of all of this is to help the judge to understand why it's necessary to adapt the normal pre-trial or trial process to meet those needs. And the way that you can help the court to do that, well, number 1, try as ever to be specific and structured. Number 2, use evidence. And number 3, where you don't need to, don't reinvent the wheel. Use what's been set out in the criminal practice direction, because lots of it is really good and really helpful stuff. So next slide, please, Richard. This is my tip number 3. How do we be specific and structured? So here's some ideas. Think really carefully about what the particular needs are of your client. So the criminal practice direction really helpfully recognises that many of the children and young people in the criminal justice system have communication needs, and we've heard from Catherine on that already. But think really carefully, what are the specific needs of your client? How do they manifest themselves in the specific context of the courtroom? What difficulties, what barriers to your client's effective participation do they create? And once you're clear in your mind about that, you can then turn to address the next issue, which is what modifications or adaptations would help your client. And importantly, why they're necessary to ensure your client's effective participation. So if you're going to be relying on best interests arguments or the welfare duty, all really good stuff, as Catherine has talked about, be specific again. How is it in your client's best interest that they receive the support that you're arguing for? How might his or her welfare be adversely affected if they don't receive that support? What kind of intimidation, distress, anxiety, ill health might they suffer in consequence? Be specific. Finally, I think it's always quite nice to be able to say that what you're proposing is going to help further the overriding objective of dealing with cases justly. You're not there to make anyone's life difficult. You're there to further the overriding objective and ensure that everybody's complying with the law. But here too, try and be specific. So what is it about the nature, gravity of the offence alleged? What is it about the complexity of the issues, or perhaps the consequences for your client, that in this specific case militate in favour of the adjustments that you're arguing for? If we can have the next slide, please, Richard. Tip number 4, evidence. As I've mentioned already, evidence is in these contexts really important. In many cases, it's going to be absolutely vital. So what that means is when we're having conversations with our young client and the people closely connected with them, whether that's family members, whether that's yacht workers, social workers, mental health professionals, we're thinking about who out of those people might be able to provide us with evidence, who can do a report or a witness statement, essentially to add substance and weight to the arguments that we're making. You can then use that evidence to make a structured argument for why a particular modification is required. So you could, for example, adopt the kind of approach that we see in the new Criminal Procedure Rule 18.27. This applies specifically in relation to intermediaries, and Mr. Justice Davis took us through some of that already. But it's quite a helpful template to show you the kind of steps that will arise, not just in the context of an application for an intermediary, but may also arise in the context for other modifications or adaptations. So you could use the evidence that you've gleaned to try and explain, for example, what your client's views are about the proposals, which may be really powerful given that your client is at the heart and centre of all of this. You could use the evidence to explain the likely impact of your client's age and, if applicable, level of intellectual ability or social functioning on their ability to give evidence and or to understand what's being said and done by the court. Use the evidence to explain why the conventional default arrangements aren't going to be adequate. You might have evidence about any assistance that your clients received in the past, perhaps whilst giving evidence in legal proceedings, perhaps while being questioned in connection with an investigation into an alleged offence, or as a defendant in a criminal case. What you want to be doing, and it sounds obvious, but it's just gathering a body of evidence so that you can make your application as robust as possible. My final tip, next slide please, Richard, is where you can use examples. So I think many judges are more comfortable knowing that they're not breaking new ground. Obviously, every case is going to be different, but particularly where you're asking the court maybe to make a modification that isn't specifically set out in a criminal practice direction, see if you can find examples from other cases in which judges have demonstrated creativity or flexibility. And that might just be a matter of speaking to colleagues, might be a matter of asking the Youth Justice Legal Centre, or doing a simple Westlaw search where you might be able to see some cases that have been appealed and there's a discussion of modifications that may or may not have assisted the defendant in having a fair trial. So if you're in the Crown Court, the PTPH form is going to do a lot of the legwork for you. There's actually a section of the PTPH form under the heading Judicial Orders, which is called Young, Vulnerable, Intimidated Defendants, Measures to Assist that can be granted at the PTPH. We can have a look at an excerpt of that form on next slide, please, Richard. So if you're using this form online on the digital case system, you might need to click and expand in the corner of the box to actually see this section. It can be a bit easy to miss it. And as I say, it's under the section to do with judicial orders. But this is just a really helpful part of the form. And the whole reason why it's there is because when there were some amendments being made to the PTPH form back in July 2019, there was a recognition that further steps were perhaps needed to promote better understanding of and compliance with the criminal practice direction. And that perhaps goes back to the point that Catherine raised about the need to raise awareness so that this does become more familiar. And hopefully, as judges are kind of going through these forms and are being prompted literally on every occasion to consider, does this apply? It will just become a bit more of a routine exercise. The section of this form has a really useful reminder, actually. It says the court's required to give reasons for departing from the relevant provisions of the criminal practice direction. So that's something to bear in mind if you're starting to see any signs of judicial resistance. Quite often that can help to focus the mind. But basically, I've set out here the section of that part of the form that provides for the various different modifications or adaptations that are specifically set out in the criminal practice direction at part 3G. And this checklist just mirrors the criminal practice direction. If you've got the guide to hand that has been prepared, you'll see that they're also set out at Annex 1. So get the judge to, look at this part of the form. If you're saying, I need my client to have a suitable supporting adult, a parent, a support worker, or some other appropriate person to be available and to be near them throughout the course of the proceedings, well, look, there's a box here. All the judge has to do is tick it, and that will effectively be the judge's direction. Remember, though, that this list isn't exhaustive. We can see that from the final box at the bottom there where it says other, and the space that's left for the judge underneath it to make a tailored direction. And actually, if we just jump back one slide, please, Richard, you can see here the final bullet point. If it's necessary, and hopefully in most cases now, this should be a given, but just in case it's not, there are here the key authorities that basically support an argument for modifications that aren't set out in a criminal practice direction, but which you nonetheless contend are necessary to ensure your particular client's effective participation in a particular case. So don't feel that you're constrained by the criminal practice direction. It is an excellent starting point, and in many cases, it'll give you everything that you need. But if you need to go further, the law is on your side for you to do that. So hopefully those tips help. I don't think there's any magic in them. I'm sure many of you are doing many, if not all of these things already, but I hope that they are just a useful reminder and maybe a guide in any cases that you've got coming up. So thank you very much for listening.
Thank you so much, Daniela. That is so useful to have those practical tools and guidance through the practice direction. And I feel like that the point within the PTPH form that it's a non-exhaustive list is really key to practitioners to be thinking about what modifications are actually needed for their particular client rather than those that are just spelt out within the practice direction. So I really appreciate you drawing attention to that. Thank you. I think we'd like, if we could go to the questions now, and I would encourage the participants to add questions that they may have into the chat so that we can ask your questions. I have loads of questions. I'm really curious about lots of different things, but it's this is your opportunity to ask questions for the panelists. Before we move on to questions, I feel like I've forgotten to thank Claire Mauer, who's a barrister who helped a great deal in within the guide as well, setting it out into the format that Daniela mentioned so that it should be easily usable for a practitioner on their feet. So thank you so much, Claire, for all that work as well. The first question I have is to Catherine and the judge, which is a question from the audience around training for judges and advocates. I know, Catherine, you've done some training with the Judicial College, and I'm sure, Judge, you have prepared training for them as well. But are there any specific trainings that judges and advocates must have in order to understand the particular vulnerabilities of child defendants and to help with their effective participation within the court process? Judge, if maybe I can start with you.
Well, it depends which court you're talking about. If you're talking about the youth court, district judge magistrates courts, who certainly try all the most serious cases in the youth court, receive annual training. They start with an induction course which lasts for 2 days, and then they get regular top-ups. Refreshers is what is called in the trade, and obviously that training covers all aspects of youth court work, but a central part of it is the vulnerability, well, of everybody who's appearing in the youth court. Very many of the witnesses obviously are young, as well as the defendants. So the core value that district judge magistrates courts work to is, remember, you're talking to children. That's their sort of fundamental. It's different in the Crown Court because, as has already been observed, there are relatively few children and young people who appear in the Crown Court now, which, in my view, is a good thing. It's the wrong place for them, but they do get there. And Crown Court judges have, frankly, very little, well, they get practically no face-to-face training at the moment because of COVID, but even before that, there wasn't huge amounts of face-to-face training. What is in place, as from March of this year, is a very detailed guide, and it's called Youth Defendants in the Crown Court. It's available to judges on the Judicial College website, but it's available to the practicing profession, the professions, to the general public on the judiciary website. If you type in Youth Defendants in the Crown Court onto Judiciary UK, that guide will come up, co-authored by Heather Norton, who's a Crown Court judge with particular expertise in youth cases, and Gareth Branston, who in fact is the Judicial College trainer for youth courts on the district bench. So it's a publication that's available to the public, and most pertinently for these purposes, practitioners. I'll be blunt, I suspect many Crown Court judges don't look at it very often, even if they have a young defendant in front of them. But because it's a resource published by the Judicial College, just the same as the compendium that's available to practitioners, if I do urge practitioners to look at it, because that's what judges should be doing. And if they're not doing it, then the practitioner can say to the judge, you should be doing this, and here's why. It's in your guide.
Thank you, that's amazingly helpful. And I think someone from YJLC will post that link in the chat for the participants, so the Youth Defendants in the Crown Court guide, because as Daniela mentioned, referring people to the Criminal Practice Direction or the Criminal Procedure Rules allows the judges to realise that they're not acting outside of, or not breaking new ground, I think Daniela said. And so referring back to the Youth Defendants in the Crown Court could also be extremely useful for practitioners. So thank you for that. Sorry, Lily, it's posting the Youth Defendants in the Crown Court, which is on the Judiciary UK website. So if we could put that in the chat, that would be really helpful. Thank you. Catherine, you've trained some of the Judicial College. Can you also talk to us about training for lawyers and practitioners as well?
Yes, so first of all, on the Judicial College side, I think, I mean, I know far less than Mr. Justice William Davis about this, but I was invited by one of the previous module coordinators on the Judicial College to deliver some training on effective participation from a children's rights perspective, and also judicial communication in the sentencing context. So looking both, and I saw that the question was from a speech and language therapist, and they, you know, the expertise and so on that they bring is so invaluable. I was reporting really back on children's experiences, both in terms of that understanding, but also the kind of relational elements of communication, how important sentencing can be to communicate, to help the child feel respected and understood, and so on and so forth. I understand, I mean, I don't know the progress, but I think there is a new module coordinator who is keen to develop judicial training on a module on communication. It's not my place to say anything further about that, but hopefully I think it does seem that it's very much alive, you know, something that's very, that the Judicial College are very much aware of, and want to make improvements on that as well, including perhaps in the Crown Court compendium. There was reference in the introduction to the last edition in December that they're hoping to include perhaps some changes to the compendium on that as well. In terms of practitioners, then, yeah, you know, again, absolutely essential. YJLC obviously provides really excellent training for practitioners, including on that communication side. I think the question that was asked is absolutely essential. It's not for it's not for children to have to do the hard work to communicate with the court. It's absolutely for the judges and for the practitioners and the lawyers to learn to communicate with the child, and that includes what I've learned from speech and language therapists is that even the most simple words that we take for granted, like victim or arrest or pleading guilty, they're not understood, and they need translating, if you like, into very straightforward language. So I think it's a really important question that was asked, and I do think it's on the. It seems to me it's on the very much at the forefront of the Judicial College, I think. So hopefully there'll be more specific training on that.
Thank you, Catherine. And I know the Inns of Court College of Advocacy is in the process of designing a course for, well, and it will be a course for everyone, all practitioners, but specifically for barristers about advocacy representing child defendants. So yeah, that hopefully will be available soon too. This is a question for Mr. Justice Davis and Ed, who both sit on the Criminal Procedure Rules Committee. Judge, you mentioned that the Criminal Practice Direction is going to be updated soon. Do you have any idea when the revised version, do either of you have any idea when the revised version will be enforced? And are you able to give us an indication of what you think will be happening to the Criminal Practice Direction when it is revised? Hope that made sense.
As to timetable, as I said, I think when I was speaking earlier, don't know. When this process of review was first put in train, which was in July of last year, the hope was expressed that it would be completed in order to allow the new practice direction to be published in April of this year. Well, obviously that hasn't happened. The process, once the reviewers have come up with their proposed new practice direction, will be that it will have to come to the committee, and it's going to be a substantial piece of work to look at it. So that's not going to happen in one meeting. I would guess that even if it arrived on the desk of the secretary of the committee tomorrow, which it shows no signs of doing, that it'll be the end of the year before it's introduced. It requires, I mean, normally it happens in April and October, new variations on the practice directions. I suspect an entirely revised version, the Lord Chief would do it whenever it were available. And it has to be emphasised, it's his practice direction. So even when the committee's looked at it, he's got to decide whether it fits the bill from his point of view. But I would emphasise it's not there to completely change the landscape. Its intention is to try and make it simpler and more straightforward, because it has got pretty complicated in some parts. And there are parts of it that frankly are of no interest to anybody. I mean, there's a whole section on listing, which just is of no interest to practitioners or indeed anybody apart from listing officers and presiding judges, and that can be shunted off, I would have thought, into other parts of the system. So it's going to be trying to simplify and trying to cut out stuff that really doesn't belong there. But when that will happen, not sure.
Thank you very much. That's really useful. I think we had to have that thought when we were deciding whether to publish the guide or whether to hold off, but we decided to go ahead as is, given that indication that it's not going to be a landscape change. Ed, do you have anything to add with regards to that? Sorry, I think you might be on mute, Ed.
Sorry, because two different ways of meeting. No, nothing really significant to add. It's the practice directions treated slightly differently by the committee to the rules. So we wait for it to be sort of delivered to us rather than to perhaps as actively pull things apart as we do with the rules.
Can I ask you a follow-up question, Ed, when you're just saying that about the rules, because obviously there have been recent amendments to intermediaries within the rules, and the judge indicated that that was as a change of recent case law. Does it mean that the rule, where there's a kind of disparity between the rules and the practice direction, should the rules supersede the practice direction?
Well, the rules are the secondary legislation, so they're the tablet, as it were, and the way the rules develop is, yes, from case law, the Court of Appeal may bring cases to the committee's attention and say, we'd like you to consider a rule change as a result of this, or it can be any group. Just Kids Law, for example, may get in contact with the committee and raise issues, and the Secretariat, who, Mr. Justice William Davis described Jonathan as an incredible man. He's just full of ideas bubbling over always, so he's constantly on the lookout for changes that can be made. And so yes, so fundamentally it's the rules that the practice direction then builds on and is a commentary to, a roadmap to. I think I described it.
Brilliant. That's very, very useful. That's very useful. Thank you so much. I didn't know if I was on mute there. Daniela, we've got a question from the audience for you, from a paediatric speech and language therapist who's also a registered intermediary. You referred in your talk to the hurdles that you have to jump through to get an intermediary appointed. Could you explain what some of those hurdles are? And can you talk about how we can educate the professionals in the court settings, as to the judges and the advocates, so that they can adapt the court to the needs of the person who needs communication support?
So on the intermediaries question, I mean, it's a seminar in itself, and I know that there is actually a whole separate guide about this that the YGLC have produced. So I'd recommend you have a look at that. The most recent guide, the one about the criminal practice directions, has a section on intermediaries, because there's a specific part of the criminal practice direction at 3F that deals with intermediaries. And what we've tried to do there is interweave some of the recent amendments to the criminal procedure rules that deal with intermediaries into the sort of framework that we've set out, which is really following the criminal practice direction. But in sort of very, very broad terms, the new amendments to the criminal procedure rules make clear that the court is duty bound to exercise its power to appoint an intermediary for a defendant, where that defendant's ability to effectively participate is likely to be diminished because of their age. And so they will look at specifically whether that support is needed to enable the defendant to best give their evidence, to understand what is being said and done by the court. And there are specific criteria that I think it was Mr. Justice Davis had set out on his slide that the court basically must have regard to. So it's quite a structured decision-making exercise. So maybe when I said hurdles that the court needs to jump through, that wasn't perhaps the best way of putting it, but rather that there are a number of matters that the court should specifically have regard to, and they include the things that I actually referred to when I was saying you could use those as a template really for arguing for any modifications. And they include things like what does the young person say, what views have they expressed about how they feel they're going to be able to engage with their trial and their defence, and any assistance that they might have received previously. Any assessments that have been done by, well, firstly, the proposed intermediary obviously is going to be really important, but also you might have any assessments by other professionals, including mental health professionals. So really, it's more about, again, going to the rules, then going to the criminal practice direction, and just making sure that when you're making your submissions to the court, that you're just ticking all of those off, because it's there to help, really. The second aspect of your question, Shawneen, I think, was that about what practitioners can do in terms of sort of helping to be on top of everything. There's quite a good sort of pointer in the criminal practice directions themselves. So there's some really useful guidance by the Advocacy Training Council. It's called Raising the Bar, the Handling of Vulnerable Witnesses, Victims and Defendants in Court. And then the Advocates Gateway has also published a number of really helpful toolkits. They're really practical, and they just help to encourage a focus on questioning. So that's where they're really useful. And this is what Catherine was talking about in terms of how we as practitioners speak to, engage with the young people in the criminal justice system. So definitely have a look and get up to speed with some of those resources, because they're there to help, and they're based on lots of research and best practice.
Thanks so much, Daniela. And I think that there is vulnerable witness training as well, isn't there? That's, I think, also provided by the ICCA.
Yeah.
That barristers are required to go through, I think.
If you're doing certain categories of cases, you definitely need to do that. If you are frequently representing individuals in the youth court, there's when you're sort of renewing your practicing certificate, you need to certify that you're up to speed with your training in relation to the specific attributes and practices that you need when you're representing young people and asking questions of them in court.
Thank you. The next question, I think, is probably for Catherine and Daniela, which is that sometimes courts push back on applying the UN Convention on the Rights of the Child. How can an advocate make specific child rights arguments to persuade a court to provide the support contained within the criminal practice direction? And can you think of any specific court decisions an advocate might refer to? Catherine, if maybe we could start with you.
No, I was going to say, I think this is probably one more for Daniela on the practical side. In terms of the court decisions, I mean, there's plenty in the so the Durham Constabulary. So in terms of like the House of Lords or Supreme Court referring to how the UN Convention on the Rights of the Child, including the general comments that I put up on the slide earlier, how they should be used to understand what our requirements are in terms of protecting children's rights. Durham Constabulary from 2004 in the House of Lords is often used, but the more my mind's gone blank. ZH Tanzania in terms of best interests and understanding Article 3 of the UN Convention on the Rights of the Child, the best interest of the child as a primary consideration, and how that links to Article 8 in that context, but can be more widely understood, I think. I've actually got a whole spreadsheet of where the courts have referred to the UNCRC. Interesting, I was just looking at it earlier, and Article 3 is used in quite a lot of the youth justice cases, more than Article 40. So I think it does tend to be, I don't know whether they're more, whether the High Court and above in judicial review cases are more receptive to welfare type arguments. I don't know. I don't know what Daniela's experience is in the actual in trials and so on.
Yeah, I was just going to say, be really conscious of what forum you're operating in. So when you're in the youth court and the Crown Court and there's a really busy list and you want the court to give you a direction, I think they might not thank you for, going through or providing really detailed skeleton arguments, which might be beautifully argued and are obviously, there's a huge amount of really important precedent in there. But I think it's about striking the balance, isn't it? And recognizing that actually the criminal practice direction is drafted with these principles in mind, and it's trusting that the sort of a lot of the legwork has already been done at that stage. And certainly if you're making arguments about best interests and welfare, I think try and make them really practical. So we want to sort of, rather than banging on fists and talking about the Constitution, we want to just be really practical and using what's already there. And then, if you've got a big challenge in the High Court or the Court of Appeal, maybe that's the stage to be doing some really detailed legal research. But again, I think these principles are now very well established. There's no doubt about them. It's more about raising awareness and on a day-to-day level, ensuring that they're made a practical reality, which is really about raising the need for modifications and taking judges to the PTPH form and the specific box which says, look, here are all the things that, you know, that may be helpful, and there may be others too. So yeah, that being practical would be my advice.
Can I, just on Catherine's point about welfare arguments rather than best interest, do you have a view that depending on what forum you're in, which ones are more persuasive, taking a welfare argument or a best interest argument, or do you think they're interchangeable?
Oh, are you asking me?
No, I was asking Daniela because you posed the question. What I wondered what because Daniela said it depends which forum you're in, I think.
I mean, yeah, I mean, I would, given the 1933 Act and welfare being, you know, in domestic legislation, that makes it, I mean, it's obviously, like Daniela says, it's a vague term that you need to give actual specific and be able to say what exactly this means for this individual child and how it can be met. I don't know whether, I don't know how they do. I mean, would you see them used interchangeably, Daniela, in day-to-day practice, those terms?
I mean, I think you probably see them thrown about in a sort of, you know, general sense of, look, you know, you, the judge, are under the obligation to, you know, protect and promote the welfare and best interest of the child. So, I mean, you see both of them. I guess my overriding advice, as you were mentioning, Catherine, was to just give colour to those, because they don't mean very much in the abstract unless you can be specific.
Do you mind if I?
No, please jump in. I'd love
the judge's view.
Yes, definitely.
The judge is interested in whether the person who's on trial will get a fair trial. Mm-hmm. Now, for, you know, if I were on trial, the judge wouldn't have to think very long about whether I was going to get a fair trial, other than whether, you know, the evidence being called was admissible and I was properly represented. But if it's a child, then the considerations are different, and he's still interested, or she is still interested. Is this person going to get a fair trial? And so, for instance, if it's a 13, 14-year-old with on the syndrome, or got learning difficulties, whatever it is, having a fair trial means they're going to have to understand what's going on, which they're not going to be able to do on their own. So that's the thing to hammer home. You can't have a fair trial if you don't understand what's going on.
Thank you. That's such a useful note for practitioners, and a point for us to end on. That's been such a brilliant webinar and really, really useful for all of us who represent children in the criminal justice system. Thank you so much, all of you, for giving up your time and bringing your expertise to the group. Please do use the guide if it's helpful, and contact YJLC if you've got any further questions. Thanks so much to everyone who's made this possible at Doughty Street, and Katya and Ruth and Lily for working so hard behind the scenes on this. Have a great afternoon, and thank you very much.
Thank you.
Thank you. Bye.
Bye.
Bye.